Nnamdi Kanu, leader of the banned Indigenous People of Biafra, IPOB, caused a stir at the Federal High Court in Abuja after his bail request was denied. Kanu, detained for alleged treasonable felony, sought bail or transfer from the Department of State Services to prison or alternatively house arrest. Judge Binta Nyako rejected his plea, advising him to appeal. She ordered the DSS to allow Kanu access to his lawyers and a doctor of his choice in a clean environment. Now, Nyako warned that repeated similar applications by Kanu's legal team would be seen as judicial abuse. To discuss this, we are joined by legal practitioner Stanley Negbenebo. Of course, thank you for joining me on the news at this time, Stanley.
Yeah, good afternoon.
Good afternoon. Now, let's talk about the legal implication of this particular denial of Kanu's bail request. I mean, this issue has been ongoing for quite some time. What do you make of it?
Well, Justice Binta Nyako's decision yesterday declining the bail application filed by lawyers to Nnamdi Kanu was predicated on reasons that are in tandem with the law. If you carefully look at the dictates of all of what she said yesterday, first and foremost, this is someone who had been granted bail before and he was nowhere to be found after a while. Basically, that means he became a flight risk having jumped bail before. An application for a bail a second time, though legally allowable, but I don't think he met the conditions precedent for such. More importantly, the sureties that actually had guaranteed him at first on bail have withdrawn their suretyship. Therefore, the bail had nothing to stand upon and therefore had to fall like a pack of cards. As it relates to whether or not they could bring similar applications, yes, the law allows you to apply for bail as many times as possible, but not on the same grounds, not on the same issues. Hence the justice's statement that any other application should be taken to the higher courts at the appellate level. Therefore, it's a step in the right direction.
All right. Now, how might Judge Binta Nyako's directive for Kanu to have access to his lawyers and a doctor impact his legal strategy and also the conditions of his detention?
Well, if you look at the charges that have been proffered against him, these are charges that border against terrorism, that border around national security. I'm sure it's a deliberate decision to keep him in the custody of the Department of State Security because of the volatility of how jailbreaks have happened in prison custodies recently. As to whether or not he's entitled to all of what the court has granted him, yes, I agree. Constitutionally, you have and you must always have your access to your lawyers. Of course, maybe with supervision, but not as stringent as the DSS facility seems to be like. Of course, he also has the right to access to medical facilities of his choice, because basically these are fundamental rights that are guaranteed. The only reason why I think they will be holding him back at the moment is basically to just ensure that he's available to stand trial. And that is just the essence of what it is. There are tendencies for our security agencies to go overboard, hence the need for the judge to actually make those definitive pronouncements so that there are no gaps for them to exploit.
All right. Now, what are the potential consequences for Kanu's legal team if they continue to file similar bail applications despite the judge's warning?
Well, in law, there's what we call abuse of court process. Abuse of court processes emerges when you file applications before a court, either to irritate or an issue that has been decided already before. The appellate system is set up in Nigerian jurisprudence to ensure that if you do not agree to a decision by a lower court, you go to the higher court. And I think that they have an opportunity to escalate it to the appellate court and then eventually to the Supreme Court. Incidentally, the first bail application that they got eventually was gotten from the Supreme Court level, so they should exploit all the appellate processes effectively. So coming before the High Court again may irritate the judge, and it may come with severe consequences, which are consequences of abuse of court processes.
All right. Before I let you go, how does the rejection of Kanu's bail request reflect on Nigerian judicial system, particularly handling of high-profile cases like this?
to be honest, legally speaking, I do not see any impact. But if I were to weigh in on the political considerations of the current trial of Nnamdi Kanu, I think that it is actually important that a political solution be found to resolve this issue, and effectively so. If the unity of Nigeria is what is paramount to the government, I think everybody should be brought on the table, hear their grievances as long as they ventilate their grievances legally. And of course, at the end of the day, reconciliation should always be pursued because the cost of maintaining peace is actually always cheaper than you having to de-escalate violence when it comes.
All right, Barrister Nnamdi Kanu, thank you so much for your time on the news.